Okay. Well, we are officially live. I know we're a couple seconds early, but we've made it exactly on time now. So we're into our brand new Liberty and Legacy webinar. And just for everyone's information, this presentation will last about 45 minutes. Questions at the end. So basically, anything that you have, you can certainly put in the text, or wait till we conclude, and then we'll go over as many questions as we can in that time period. But this is kind of an exciting one for us. This webinar really is done in conjunction with America's 250th anniversary. That's the best way to describe it. We call this webinar Liberty and Legacy: How to Stay Independent Through Planning. And I think the two ideas kind of coincide. The ability of our country to remain strong is based on our independence, and the ability for you as a person going through their life having things set up to allow you to be independent and strong, I think is equally as integral. But we're going to talk about everything in depth. And again, this is an opportunity to learn and educate yourself on it and ask as many questions as you can because we have that opportunity. So we're going to get going and jump right into it. And let's go through our official legal disclaimer. I'm going to pop down a little bit. And we call this our official lawyer disclaimer, which means this webinar is for educational purposes only. It is not legal advice. Laws vary by state and your individual circumstances. Of course, we won't be able to specifically address everybody's individual circumstances. That's why we put this disclaimer in. So, what does protecting your independence mean? And I want to start this off by telling everybody, I mean, if you look at your life, you look at the things that you do every day, and again, some things are easy. Some things, some people may be very handy around the house. They can put together an air conditioner that breaks, they can fix plumbing. Other people may be incredibly attuned to their work, good with numbers, good with reading. So these are all the things that you're really good at. But as far as the rest of your life, planning for the future, getting your legal documents and your legal protections in order, some of these things may be foreign to you. They may be things that you don't normally think of. So when we talk about protecting your independence, it means still continuing to do all the things you do well, but also getting better and learning about all the things that you may not be as educated on, and putting all things together so you can remain independent as a worker, as a member of a community, as a member of a family, but also having all of your legal protections and documents in place. So I can tell you what independence means to me in terms of the ability to go to work every day and work hard for the people we service, as well as deal with all our coworkers and family and create a good environment for everyone. But what does independence mean to you? If it's not just living alone or remaining physically healthy, what does independence specifically mean to you? You have a workbook. Hopefully, you've downloaded it. It's a tool that you can start to write down and basically form a type of thinking. Because I want you to really look at your life and look at it in a pragmatic way. Like, what makes sense to you? Do you feel at ease when you wake up in the morning, or do you feel a level of stress, a level of worry? Do you feel like things are closing in? These are all things that as we age, we may have a different sense of the world. So look at the things that are important to you, which means control for most people that we deal with. You look at your finances. You look at your health care. Are you feeling well day to day, or are there things you're concerned about? Look at your property. If you own property, if you rent property, if you're involved day to day with the place that you live, are there things about that that make you concerned? Your legal affairs. Do you have your legal documents in place? Wills, trusts, power of attorney. Are things set up so you're comfortable? And also your personal wishes. Where do you want things to go? How do you want to be remembered? What's your legacy look like? These are all the things that are incorporated into your independence. And when we talk about independence, one of the legal tools that kind of goes hand in hand with that is a power of attorney. And let's jump right into this. Why is this so important? Why does power of attorney become literally the first thing we talk about every single webinar? It's because something happens, God forbid you have a healthcare crisis, an issue, you're unavailable to take care of your bill paying. Having a power of attorney allows a trusted individual, a trusted person, to make financial decisions for you. It allows you to avoid what's called an Article 81 guardianship, which can cost $15,000 to $20,000. This simple form, which usually costs $800 to $850 or similar around that total, that will allow a person to pay your bills for you, move money around for you, get you eligible for Medicaid, protect you from creditors, set up trusts. They can do everything. And if you're unable to do those things, this power of attorney can keep your life working as well as possible. I mean, independence is not just staying alone and staying in your own little Rapunzel tower. This is about being able to live independently without much help. But when you do need help, you have a person that you choose to make those decisions, pay your bills, keep you at home, keep you secure. So independence, and it's kind of like you think about the independence of the United States, like we needed help. We couldn't do everything on our own. I mean, America was formed because we created some pretty powerful alliances with France. We had funding from the Dutch. We had other help from Spain and other places as well. So independence was not just us in a bubble all by ourselves fighting for our lives. Independence meant we had some help to keep us independent and keep us strong. So think about that with your power of attorney. So as we talked about, what does a power of attorney specifically do? Most important when you're in a healthcare issue or crisis, your power of attorney, your agent on your power of attorney can pay bills for you. They can manage your bank accounts. They can handle investments. They can buy or sell property, maintain your home. You could change beneficiaries. You can handle safe deposit boxes. You can be expansive with your power of attorney options. One of the things the New York Power of Attorney did was allow modifications. So you could put specific modifications tailored to your financial life. You can communicate with government agencies, including Medicaid. So your local Department of Social Services, your agent can handle those specific tasks. And again, this is a very important tool because you never know what's going to happen. And if you don't have the power of attorney, I think there's nothing quite like this. Because if you don't have a power of attorney in place, then the people closest to you, your loved ones, have to initiate what's called an Article 81 guardianship, a court proceeding, a significant court proceeding in Supreme Court. And if we know anything about court proceedings, you don't want to end up in court if you don't have to. So please think about that. But ultimately, a power of attorney is a straightforward, simple document that can really change your life for the better. Of course, pairing your power of attorney with a healthcare proxy is the ideal situation when you talk about advanced directives. And you're going to hear about advanced directives. It's a term we use all the time. These are the planning tools that you set up ahead of time before something happens to you, physically, mentally, that will impact your overall quality of life as well as decision making. So a healthcare proxy allows you to, just like you did with power of attorney, to appoint someone you trust to make medical decisions if you cannot communicate your wishes or advocate effectively for yourself. And by planning ahead, you can ensure your healthcare decisions are reflecting of your values and preferences during a crisis. One thing to keep in mind, power of attorney, you can have more than one agent under a power of attorney. Let's say you have 3 children. You could make all 3 children power of attorney or 2 out of the 3 power of attorney and have one as a backup. Healthcare proxy is different. Healthcare proxy only allows one individual at a time to be your decision maker. They don't want to have people conflicting during these very tricky moments in a person's life. Because a healthcare proxy is deciding on what treatments you're going to be receiving, what type of discharge planning, whether you're coming home, rehabilitation, nursing home, assisted living. These are all things that they'll be deciding. So you really want to make sure that that singular person reflects your values. Now, of course, when you ensure that person is speaking on your behalf, you're choosing someone you really trust, hopefully someone close. You're also reducing uncertainty during a medical emergency. We tell everybody year after year, when you get your healthcare proxy and your healthcare decision-making forms, put it on your refrigerator. This is one of those old things we've been telling this for decades, because of course, when an emergency EMT person comes to your home during a crisis, the first place they're going to look is on your refrigerator to make sure that who is decision making, is there a DNR, all the things that we're going to be setting up if we do work for you. And of course, when you have a healthcare proxy form, it's not just for EMT and emergency, it's also for all of your healthcare providers. We always encourage every single person that does this type of work, creates these forms, make as many copies of these healthcare proxies, give it to your primary care physician, give it to your specialists, anyone who's going to be working on you. Of course, in an emergency, there's going to be hospitalists, there's going to be social workers. Everyone needs to see that. Make copies, that's fine. Certain documents, we're not a huge fan of making tons of copies and handing it out. Healthcare proxy, though, is one you should. And of course, when you create a healthcare proxy, usually you'll include things like your living will or your directives allowing your decision maker to decide what kind of end of life you want. So when you do these forms, you're also helping your loved ones make informed decisions consistent with your wishes, and you can tell them that. Because one of the secrets of doing the advanced planning is understanding that these documents are a guide. When a person is sick, the providers, the healthcare professionals, the doctors, the hospitalists, they're still going to be talking to your healthcare proxy and asking, what do you want us to do? Do you want to have a DNR put on? Even though you may have your wishes, in the real world, they will check with loved ones to see what the continuum of care is going to look like. So just be aware of that level of thinking. Just because you write it down and say, this is what I want, this is my writing, this is perfect, I love it. In the real world, the doctor is going to talk to your healthcare proxy if you've lost the ability to advocate for yourself. Now, a relatively new form in terms of how we do our advanced directives, but a necessary form, is what's called the HIPAA authorization. Now, this is so important considering the interplay between all the different medical professionals that work with you, from primary care to specialists to any type of hospital staff, medical staff, rehabilitative staff, long-term. This is an unbelievably complex web of medical professionals working on you. So one of the tools that we have added to our little arsenal of advanced directives is what's called the HIPAA authorization. Legally, it gives trusted individuals permission to access your protected medical information if it becomes necessary, which means you can advocate for yourself, you can make these decisions. A trusted person can gain access to your medical information and dispense it as needed. But of course, without this document, healthcare providers may be unable to share important medical information, even with your spouse, even with adult children, or other close family members. And this comes into play if you think about a loved one, you think about a family. You may have a child that's just hit age of majority, just hit age 18. And you realize that as soon as that birthday hits, the second the candle is literally placed on top of that birthday cake and the candle's lit, that exact moment is when your child becomes an adult and their medical information, their legal powers suddenly trump your ability as a parent to make decisions and get information. So you really have to think about your own children and family. Once they turn 18, you have to get their planning, get their advanced directives, get HIPAA forms to allow you to make those types of decisions and gain information. So HIPAA is not just an emergency, it's also for day-to-day family life. But of course, when you have HIPAA authorization in emergency, you reduce delays, because when you deal with hospitals and doctors, and everyone on this webinar has been in the same position I've been in, my family's in, you're on the phone with the provider, you're on the phone with the back office, you're trying to set up an appointment, and of course 6,000 people are also trying to make the appointment, you're on hold, they don't have an availability. It's a never-ending just energy suck of getting things accomplished slowly. We talked about living will, and of course, a living will is different than your last will and testament. And it's funny, we do this type of work in law, and it's amazing. When I started doing this almost 30 years ago, the fact is, when you learn about a living will and then a last will and testament, and you constantly have to explain, no, this is not a will, this is a living will, and this is not a living will, this is a last will and testament. Just think about it very clearly. A living will is really your set of end-of-life instructions to make sure that you're not just kept alive in a vegetative state for no reason. Whereas a last will and testament is just leaving your assets to people that you choose when you die. That's it. Very different. A living will, again, in terms of how we describe and define legally, it communicates your wishes regarding life-sustaining treatment if you're unable to express them yourself. It gives guidance to your loved ones, to healthcare professionals, in terms of what type of medical care you want in certain circumstances. They want to make sure your preferences are respected. But again, how this works in the real world is no question a medical professional, a doctor, a hospitalist, someone working with you in that capacity is going to talk to your healthcare proxy if you can't advocate for yourself. And they'll see your living will, and often they will follow it, but I've seen it in both ways where they will still confer with your loved one who's a healthcare proxy to ensure that your living will instructions are still what's on the table. Of course, in the absence of a healthcare proxy or an absence of a person making those decisions, having that living will form does give guidance for end of life. New York also has what's called the MOLST form, the MOLST form. It's a bright pink form. We throw this in every webinar. It's just one of those things that it's a really important document, especially if you do hit a point where end of life is imminent. This is a living will is usually done along with all the other documents in an earlier stage before something really catastrophic has happened. But let's say you have a diagnosis, something is incredibly serious, and you still have capacity. People do a MOLST form to provide very specific guidance, and it's signed by a doctor. This is not a bunch of lawyers sitting around drafting a form. MOLST form is a document that is prepared and executed with the assistance of your treating physician. And it's bright pink, goes right on your refrigerator door, or at least close by, in the same packet with everything else. So now you've had some time to think about it. You'll hear me discuss it. Again, if you have your workbook, go through, look at your planning check. Again, do you know, again, how things work? And we'll talk about this coming up, because now we're going to talk about your actual will and trusts. So I want you to think about this for a second. This is going to be our entry point to the next phase of this conversation, which is your assets, protecting your money from probate, creation of trusts. So healthcare advanced directives, I hope you have a good feel for that. But this is our next part. So number one, do you know whether your assets right now that you own will actually follow your will? What happens if your home never goes through your will? And then how do some families avoid probate and do all assets pass through an estate? So now, as you start to think about the assets you have, we talk about independence, you talk about what will make you strong. Obviously, having your health set up, having all your advanced directives in place, that keeps you secure on that level. But the next thing, of course, is the money you have, the resources you have earned over a lifetime, what type of investments you've harnessed, as well as the place where you live. How do we protect it? So I want you to start thinking about that now for the next part of our presentation, because this makes the difference between not just surviving, but also thriving. And the first place we're going to start, even before a will, is we're going to talk about trusts and why they're so important, how they benefit you, and why avoiding probate and putting things in a place where there's a level of either control or direction, it just makes all the difference to you and your loved ones. So the first thing we're going to ask everyone to think about is, what is a trust? Now, this is something everyone talks about. Every lawyer brings this up. Legally speaking, a trust is a legal arrangement that allows assets to be managed according to your wishes during your lifetime, as well as death. Now, what differentiates that from a will is just something that is only basically a set of instructions that comes to pass when you pass away. And that's it. It's not something that's managing your life. It's just a document that deals with the assets you hold in your name alone, not anyone else's name, no beneficiaries, no joint account holders, only what you own when you die. That's what a will does. Those assets then go into probate. You deal with courts, lawyers, sometimes unnecessary expenses, complications if there are family members that are not included in that will. Wills are a stopgap measure if you have nothing else. I guess there are worse situations, worse scenarios than having a will. But the best scenario, the best level of planning always is a trust. And we'll talk about that, why a trust helps. And I think this little slide will show most of why we keep pushing it, we keep promoting it. Why is it so important? Number one, it avoids probate for assets held in that trust. So if you put your primary residence, you put your summer home in Maine, you put an investment asset that you hold with a Merrill Lynch or a Schwab, anything that you have that's an asset gets placed into this trust. Whatever is in that trust, it's going to go outside of probate. That's just how it's going to be set up. And yes, you can set those investment accounts and you can have a beneficiary that also goes outside probate. But some of what a trust protects against, if you get sick, if you need Medicaid, or if you have creditors, these are things that a trust can actually help with and protect and allow you to get even more additional services, benefits, and protections. So that's why it's so important. Number one, can't avoid that. If you can't avoid probate, you're going to have issues. Privacy, number two. Maintaining privacy, again, a trust, unlike a will, is a private document. Your will, you pass away, you put down all your earthly belongings, where it's going, who you're writing out of your will, all these things. A will, once it gets filed in surrogate's court, and now we have electronic search databases that will find every estate and every basically individual document that's allowable in that estate file in surrogate's court. I mean, that's a public record. It's a public document. So dirty laundry, issues, problems in the family, everybody in the world can see that. A trust will not be in that same shoes. A trust is a private document. It stays with the family, the trustee, the testator. It's, basically everything will stay in that little tiny world. Number three, you're providing ongoing management of assets. There's a flow. The beauty of a trust is we prepare a trust. You put your assets, your resources in the trust while you're alive, while you're competent, while everything is good. And then there's management. If it's a revocable trust, you're the trustee to start. You're managing it, you're investing it. It's still you. It's under your social, everything is good and easy. If you pass away or if there's an illness, then you have a backup trustee who continues it. We talk about in healthcare, continuum of care. This is a continuum of asset and resource management and development. It stays, there's a flow. And even if you pass away, there's no courts, there's nothing, there's no break stopping this. It's just you're continuing to manage the investments. If a house has to be sold, it's sold in the flow of the trust. It's like a great NBA player, it's like a wonderful superstar power forward that only scores in the flow of the game. They're not someone who needs the ball all the time. This is what a trust is. A trust and the people managing it, it's all done in the flow of the trust. Now, with a trust, you also get the protection for beneficiaries. So what you could do is in that trust, you can create supplemental needs trust for a possible disabled beneficiary. You can have a minor trust that holds money for a young person to allow them to go to college, have bills paid, put a down payment on a house. All these great things can be set up through your trust to protect your beneficiaries. If you just put a beneficiary on an investment account or a savings account, cool, it goes to them directly, they get the money, wonderful, but there's nothing protecting them. If they have severe issues, mental problems, other problems that have caused them to live a difficult and hard life, or they're not good with money, there's spendthrift protections. There's a whole range of things that a trust can protect. Whereas if you just put a beneficiary on an investment account, they get all the money, they blow it, it's done, and that's it. And then you've lost the game. This allows you to continue to stay in it. As far as simplifying the transfer of assets, there's no comparison. There's nothing like a trust that can just put the assets right in the hands of the people who the creator of that trust wanted to. No probate, no courts, not even lawyers. I mean, lawyers may guide the people involved, but ultimately the trustees can move it with the directions that they have to the people entitled to those assets. Just to recap, again, what is the difference between a will and a trust? Again, will takes effect at death. Trust can take effect during your lifetime. You go through probate with a will, which means you have to hire a lawyer, pay a lot of money to that lawyer, deal with lawyers and courts and delays. Trusts, done well, avoid probate, no lawyers, no issues on that end, unless you really want one, but it's not needed, unlike with a traditional will. Will is a public record, of course, no privacy. Trust remain private. Your dirty laundry, the issues in your family do not remain, stay in this little bubble that we create. And then as far as wills, the one thing that wills do, of course, is they can name guardians for minor children. But again, a trust also will manage the assets for those minor children. So if you want to say, well, a will give at least someone, if both parents pass away, there'll be a guardian named to help care for the child, and a trust will manage the funds for that child. So that's the one thing a will do. But of course, when we create a trust, alongside any trust that we create as a law firm, we do what's called a pour over will. Certain supplemental needs trusts may not have that, but every other trust has a pour over will, which directs all loose ends into your trust, as well as could provide minor protections and guardians for children. So, but ultimately, a trust is, if that's your primary document with a will as a secondary, that's fine. So again, who could benefit from a trust? I mean, because for decades I would talk to people and they say, well, that's trust, that's for Rockefellers, that's for super wealthy people. That's not something that's appropriate for me. And it would be a constant back and forth. They'd say, well, a trust costs more than making a simple will. And I'd always say, of course they do. Because when you do a will, then on the back end, you're going to have your family member or loved one pay a lawyer, pay court fees, and it'll be way more expensive than creating a trust. But of course, if you look at front end versus back end, that's the mentality. But of course, when you have a home and you own a home, you are perfectly suited to have a trust. Because again, that's the hardest asset to deal with, to protect. If you get sick, that's the asset that Medicaid will attach, put a claim in, put a lien on, do estate recovery for. So if you protect your house in a trust, that, if considering that's for most people, that's their number one asset, that's the highest valued asset for most people, this is a no-brainer. If you have young children, a trust is incredibly important too. You could have minor provisions if you get sick. Money could be set aside for them. It can grow during their lifetimes and then provide stability as they age, go into college. It's just a great tool to build and protect should something happen. If you own multiple properties, again, why is that so important? And for a lot of people in our viewing audience, you may have a primary residence in New York, and you may also have a vacation home, a condo in Florida, a place in Massachusetts. And the fact is, if you don't have a trust, you may have to do what's called ancillary probate or ancillary administration in the other jurisdiction. So you may have to have a Florida attorney, you may have to have a Massachusetts attorney go through their probate process. It's complicated, it's expensive, it's just something that's unnecessary. Because if you have your New York trust, all we do is a deed transfer. We can work with local counsel, we can set things up appropriately, but as a New York resident, you have property, deed transfers go right into your trust, and at that point, all these properties that you own, whether in New York or other states, are all under one umbrella, one New York trust, and which means you avoid ancillary probate and extra fees. Same thing with privacy. If you live a life where you have risk. Let's say you have a career or you work in a field that has tremendous risk, that exposes you to potential creditors, accidents, things where people may sue you. And this is a very common thing too. People have dangerous fields that they work in. They handle day-to-day activities with great difficulties, and there's a lot of risk. So how do you mitigate risk? How do you minimize risk? You have greater privacy through a trust that can protect things up, especially an irrevocable trust that has creditor protections, things to protect your family's well-being and wealth. And I think that's very important. Trusts are also very, very important if you have a blended family. Let's say you're in a second marriage. There's children from different marriages. You may have adopted out children, adopted in children. There's so many varieties of blended families that, if you don't have a trust, there's going to be inequality strewn throughout your estate planning. A trust can be very specific. I mean, you're creating a little novel. That's what a trust is. A trust is an actual narrative that you can set up that exactly lists what each person in your life, family members, stepchildren. You can put their roles and put their priorities in a very specific way, protects everybody, avoids problems, no courts, no probate, very, very well defined, well thought out. And then there's the regular person like you or me, just wants to avoid probate, wants to avoid going to court. So I like going into court and seeing everybody. And sometimes, if depending on which court, I'll wave to everybody. It's great, but I don't want to have my whole life and my assets go through probate. Avoiding it is a good idea. If you own a business, a trust can be incredibly useful, especially if you have LLCs. You may own rental properties, garages, you may own any series of businesses. By having a trust, you can provide that trust will pass to another generation, another beneficiary, while still maintaining operations. Because a trust can be an owner or member of an LLC. And even you may have shares of an S Corp. You may want to have those shares owned by the trust to make sure it passes to another generation, not going through probate. So there's so many ways you can keep things flowing with a trust. And of course, if you want to actually provide for the loved one with special needs and has healthcare concerns, we can put those special needs language into a trust. You can do it in a will too, but a trust is more efficient. So when you think about trusts, you're thinking about, again, have you ever in your life been involved in the probate process? Have you experienced the difficulties of probate? That may make you more inclined to choose a trust. What are your biggest concerns about passing assets to loved ones? Is there a situation in your family that you're concerned about and you want to plan for it? And the same thing is, would avoiding probate be important to your family? Do you feel like you want to put that burden on your loved ones to go through the courts, pay lawyers, deal with that level of just time and stress? And of course, what's the biggest reason you'd want a trust to be part of your estate plan? Again, simplicity, easy. This is something you can decide. That's what your work is for. Write down your thoughts. And of course, we'll talk later with any other questions. I mean, assets and legacy to me go hand in hand. We talk about your money, we talk about your resources, but again, when you put your plan into place, it's a worldview, it's a global perspective. It's not just a couple things here. I'm saving a couple of, items, of antiques for my house. It's your overall planning. I mean, that's what independence is. That's what we're here for. We're here to protect everything and give you a plan for everything. So you can sleep at night, you can wake up and know if anything happens, there's a plan. There's a person I can deal with. There's a number I can call. There are professionals who are working with me and my family. That's where we're protecting your assets. And again, your legacy is what you're leaving to your family. Are you leaving them a mess? Are you leaving them stress and difficulty? Are you leaving them in difficult situations? Or are you leaving them something that's manageable, something that is useful and you've given it thought? One of the easiest things to do to avoid problems is to update and set your beneficiary designations. And I probably have talked about this equal number of times I've talked about a trust. Why do beneficiary designations matter? Because if you have your beneficiary set up, the assets can pass directly to that named beneficiary, regardless what it says in a will. A will could say that all of your money from your Merrill Lynch account goes to Tom. But of course, if your beneficiary says it's going to Bob, it's going to Bob. It's not going to Tom. That's how beneficiaries work. And that's why we also say, you can make your trust the beneficiary of certain things. And then basically the trust can specifically describe how that money can be going to that person, protected for that person. So you have a variety of ways to do it. But as long as the beneficiary designations are completed with some thought, you'll be protected. Again, what are the things that have beneficiaries? The list has grown over time. Number one, most important thing is your retirement account. If you have a 401k, you have an IRA, you have a Roth IRA, a traditional IRA, you have a 403b, you work for the city or the state. Anything retirement account based will have a beneficiary. Make sure you choose that. That's very important. And it's always good to have contingent beneficiaries. You may put a spouse or a close person first, but then you may want to have secondary or contingent beneficiaries in case someone predeceases you. Think about that. Same thing with life insurance policies. Life insurance policies have beneficiaries. Make sure you use that beneficiary form, update it. One of the biggest biggest problems we see all the time is someone gets divorced, they forget to take off their ex-spouse from a life insurance policy or a retirement account. Now, depending on the type of account, if it's an ERISA governed account by the federal government, they won't take an ex-spouse off as a beneficiary just because you got divorced, even though state law basically presumes and says that once you get divorced, your ex-spouse will be removed as whether an executor, beneficiary, person, and anything with that designation. Sometimes, if it's a federally protected account or an ERISA account, these things will not exclude an ex-spouse who was not taken off as beneficiary. Think about that, and again, talk to a professional who can guide you with that. Annuities have the same thing, whether you have retirement annuities or regular insurance contract annuities. Beneficiary is very important. There are also TOD and POD accounts, transfer on death, payable on death. These are things offered by banks, and you've seen more of these take effect over the last couple of decades, where in the old days you'd have to have a joint account holder on your traditional savings, checking. A lot of banks realize, well, you may not want that person to have control over your bank account, your savings account. You just want them to inherit when you pass away. Very important. We also see beneficiary designations with the new transfer on death deeds, which New York State has authorized. So even if you don't want to change the title of your deed to the house, you don't want to necessarily put into trust. Some people don't want to do that. We understand that. They can still put a beneficiary as a TOD for their house with a transfer on death deed. A new wrinkle to planning. Doesn't protect for Medicaid, doesn't protect for creditors, still leaves a lot of things up in the air. But if it's purely to get it to the other generation or another person without court, it's a way to do it. And when you see the three bubbles, it usually means a reminder or a remember. Remember, outdated beneficiaries, again, as we talked about, can unintentionally inherit assets. We're not talking about ex-spouses. It could be a friend you don't speak to anymore. It could be a sibling you don't talk to anymore. Just remember to update your beneficiaries. You may want to look to see what you have written so far and then update it. So, of course, when you have a big life event, birth, marriage, divorce, death, something really major in your life, it's after the dust is settled, definitely change your beneficiaries. And again, why are beneficiaries and that type of planning so important? Because sometimes joint ownership isn't always the best solution. When you put multiple people on an asset and you title in both their names, both their social security, if one person in that jointly held group, that joint account, has a major IRS problem, a major creditor problem, their socials attached to that money, that part of that money is theirs. Creditors may gain access to it. Ownership changes could have tax implications. You may give away ownership rights. You don't even understand it. I remember I learned a term in law school called a moiety, which is basically your portion or your share of that joint account if you're multiple owners. Yeah, it's one of those things that's thrown in there, but these are things that affect you if you have joint ownership on something and you're concerned that their life or their issues may unintentionally involve your issues and cause you trouble and heartache. By having them as a beneficiary or a transfer on death, their issues, their obligations, problems with creditors, IRS, doesn't affect your accounts because their only role is a person who inherits upon your death. They don't have ownership rights. Now, of course, it's also 2026, and you're watching this on a webinar. Which means you're invested, as I am, in a digital life. You're invested in the world as it is in terms of the types of things you do day to day. What does your digital footprint look like? So, of course, your digital assets, when you think about it creatively, you have email accounts, you have cloud storage, you have digital photos and videos. And just off the bat, and you may say, well, that's all, just bric-a-brac, and that's the digital version of bric-a-brac. A little bit of this, digital photos. Photos and the videos are everything. People's memories, people's moments. And if you don't think that matters, one of the fun things that a lawyer has to contend with, and I'm not talking fun in a good way, I'm talking about the things that are puzzling. And I've seen is that you've had family members get into major squabbles over who is going to have access to a family photograph, a family video, and these are things they're willing to litigate over. And it becomes a real problem. Having a plan for your digital life, and in terms of whether it's in your power of attorney or in a trust or in a will, making sure that there's the ability for your loved ones to gain access to that digital life and then transpose it, move it to where it's supposed to go is so important. And then just for having we call this like a letter to your family, letter to your executor, letter to your whoever person in your life, always have a record of your password managers, your social media accounts. If you have cryptocurrency, make sure you tell people. And if it's just sitting out there and you want to put it into something that is actually attainable or protected through a trust, find out if the cryptocurrency that you own can be converted into a Coinbase account or another account, which can then be owned by a trust, managed and dealt with, versus having a loved one trying to fish it out, figure out where to gain access to it. And same thing with online financial accounts. Your digital life has value. You may have a whole lifetime's worth of data and intellectual property and other resources. I mean, Roblox too. You may have invested tremendous amount of money in Robux over the years. I mean, that is an account that still has value, and there should be a way to manage it. So as we age, there's going to be a variety of digital resources to help you plan. And if we take away one thing after this presentation, is just doing everything, having everything set is, again, great start, but it's not one and done. It's kind of like mowing the lawn. It's kind of like trimming the trees or pruning the bushes. It's something you will keep doing, and it will evolve as your life changes. You get married, you get divorced, you lose people you love, birth of a child, adoption of a child, you move to another state. Your assets go up and go down. Your business, your life, your work has improved. There's retirement on the horizon. All these things will cause you to take a pause, think about where you are in your life, and then adjust your estate planning or your overall planning accordingly. We're doing this all along. You're basically keeping track of your estate plan. This is not a one and done. This is, again, it's not a daily or weekly mowing the lawn, even though I like to say that but you're managing it every year. Take a look at what you have, see if there's something has to be tweaked or adjusted. It's just, you'll feel better. And I think that, for our lives, considering where they are and the ebb and flow of it, it's just a healthy thing to keep task up. You don't want too many surprises. So when you look at your own overall output of estate planning, financial resources, if you look at your workbook, you take everything out, have you reviewed your beneficiaries recently? Have you checked and made sure everything is up to date? And again, do you own any assets jointly with people you're concerned about? Do you own a house with a sibling? Do you own a house with a cousin? A vacation family home that's been in the family for 10 generations? Do you own it with a bunch of family members? Are you concerned? Are there liens? Are there things owed? Do you want to put your asset into a trust? Can you access your digital accounts? Who would be able to do it if you can't? Do you have a plan for that? And of course, when was the last time you updated your estate plan? Was it something that you did last year? Did you sit down with me 6 months ago and we had a back and forth? I yelled at you a little bit, or maybe I didn't. This is a question you ask. If it's been 5 years, 10 years, maybe it's worth a quick checkup so that we can have you on your way in a better mood. So the final piece of our little puzzle, and we'll try to run through it, is, again, planning for long-term care. Because now that your advanced directives are set up, your trust planning is set up, your beneficiaries are set up, the next thing is, if you get sick, what's the plan? Who's going to pay for it? Where would you live? How can you handle it? First of all, what is long-term care? Something I've been doing since the first second I became an elder law clerk with a small law firm in Manhattan. It's in-home care, it's assisted living, it's skilled nursing, it's memory care or adult day programs. It's how do you deal with a long-term illness whether it's aging, whether it's dementia, whether it's some other illness which is slowly degenerative in your system. These are all the things that are slowly causing you to not live independently. That's long-term care. It refers to assistance with everyday activities, activities of daily living, ADLs, as we talked about. And again, most people will require this in their life. So what is the best plan for this? Planning before you need care means that you can set up your resources to be protected, have options if you get sick, whether it's to live at home or have a facility if need be. Again, by doing this early, you put together more control over your care options, you protect your assets, because again, Medicaid in nursing home applications is a 5-year look back. Look to see any transfers. There are penalties for gifting. Whereas home care in New York, community-based home care and assisted living Medicaid do not have a penalty, but they could. There's a law in the books passed during COVID, which could have a 2.5-year look back for home care or assisted living. It's not been effectuated yet, but we're always watching it because New York State could run out of money at some point. Who knows? Even though it's a federal program administered through the states, we know how this works. You also, when you set your long-term care plan up ahead of time, talk to your family, you reduce stress on your family member. You don't put them in that grinder and they get a phone call at 2 a.m. and you have a fall, you're in a hospital, and then what do? We don't have our stuff set up. What's our long-term care plan? And you don't want to rush in emergency. And of course, when you plan ahead, you're also giving yourself more time to explore financial options, not just Medicaid, but if there's long-term care insurance, if you're still eligible at that point, you're giving yourself more ways to pay for care should you need it. And again, how is long-term care funded? If you're using your personal savings, it's going to go fast because long-term care is incredibly expensive. Nursing homes are $15,000 to $20,000 a month easy. So be aware of that. Long-term care insurance, you have to pay into the system, you pay premiums, and a lot of them can be very high depending on what you choose. But again, better than not having it. Then there's Medicaid. Medicaid requires you to become eligible for services. Now in 2026, you needed a little bit less than $33,038 to become eligible for Medicaid services without a penalty. For home care, assisted living, penalized if you move assets out for nursing home. So just be aware of that too. As far as veterans benefits, if you were a service member, if you served during wartime, you're entitled to a variety of veterans benefits. There are things called aid in attendance that provides almost a stipend to pay for care. There are also VA homes, which are really nice, and they're very protective over their veterans. And again, that's one of the benefits of serving in our U.S. military. And of course, when we talk about independence and we talk about the value of independence, what's more apropos of that? So as far as what you've discussed with your family, if you look at your workbook, have you discussed long-term care with your family? If you needed care tomorrow, who would help you? Who would be the person, who would be the anchor that steps in and does this for you? Obviously, your power of attorney, healthcare proxy would do the initial, but again, who's going to help you day to day? And again, do you know and have you considered how long-term care is paid for, whether by Medicaid or whether by personal savings or long-term care insurance? Have you given it thought? If you have, put it into your workbook. And again, what is your biggest concern about aging? We ask everybody, we talk to everybody, what is it about aging? And most people will agree, aging is difficult. It's a hard road. You lose a lot of people you care about, and it puts you in a more, needy role than you ever expected to be in. But if you have good people and good professionals working with you, it can be managed at a better clip. So again, how do you leave a lasting legacy? What is your legacy besides being a good person, a person of good cheer, good humor, supportive and loving of your family, a person that's generous of spirit, generous of resources? And what is your legacy? Did you make a great pizza? Did you have a great recipe for chicken soup? This is the real thing. What matters to you and to the people that you leave behind? We talk about legacy. You're putting your loved ones in the best possible position. You're protecting the resources you built for the family to keep the family strong. You've kept stress at a lower level so people aren't freaking out. You put people in a position to help you. You've preserved family harmony. You have not set things up in a way where people are going to fight. People are going to be disagreeing. You have not created inequality where there's no need to be, especially if everyone has acted appropriately. You've also supported causes you care about. There's charitable intent too, and ensuring your wishes are honored. There are things we do all the time, these little accessory documents. And one of my favorites is called the family agreement. The family agreement takes unspoken little agreements, unspoken handshakes, nods, winks, little things over a lifetime with the family, puts it on a piece of paper. Everyone's aware of it. You reduce stress. Family fights, sibling fights can be removed with that one piece of paper. So if you prepare, again, what does independence mean to me? Independence means you've prepared appropriately, you have the right people in place, and you've reduced uncertainty and reduced conflict. You give some clarity to people, you talk to people, everything seems to work out better. If you keep things bottled up, you don't act, you're stubborn, things are going to go bad. That's just been my experience in 30 years. When you don't engage your family and bring people together, you're pushing them apart. So keep your plan current, make sure everything's up to date. And I think once you have everything in hand, then you'll have independence the way you expect it. So again, what do you take away from today? Hopefully you choose your decision makers, keep your docs updated. Beneficiaries have to be updated, of course. A trust, so important, think about it. And then just plan before anything happens. And that's it. Again, how do we work as a law firm? And with the fellow group, we always start off, once you reach out to us, reach out to me, we do a very simple 30-minute case evaluation. Our intake specialist goes over, guides you in the right direction, tells you what the path looks like. And then once you agree and everything looks good to you, we do a letter of engagement, which is our contract, which then leads to a design meeting with our professionals, our lawyers, our paralegal staff to come up with the absolute most specific and correct plan that you need. And then you review your drafts and we do a signing. And once the signing, execution, if there's deeds that have to be recorded, and that's it. Then you're part of our professional service. You ask questions, you're with us, and generation after generation stays, and we help you through all of life's difficulties. So again, what does independence mean to you? When you write it down, just make sure everything is exactly the way you want it. And again, if you share these wishes with the people you care about, and then after this presentation is over, what is one action that you can take realistically to get this ball rolling? Thank you for staying with us. Hey, we extended it a little bit longer than I thought, 52 minutes of fun. And again, if you have questions, this is an opportunity to write in our chat, and I'll try to read what we can. We have a nice bunch of people with us today. Again, you can always call the fellow group, 845-621-8640. We have two offices, office in Mayapack on 572 Route 6, Katona, 223 Katona Avenue, Unit F, as in Feller. We didn't pick it that way. It just kind of happened, little fun things that we can have a laugh about. But I'll take a look quickly in the chat and see if we have any other questions. Okay. So first of all, let's see. The first question we have today is, if there are no close family members, who do you choose as an agent? Well, this is something we see all the time. When there's a lack of close family, whether there's no spouse, children, then I always say look at the people closest to you, whether it could be siblings, it could be a best friend, it could be neighbor, it could be a professional you worked with for 20, 30, or 40 years. Make sure you have someone. Don't just say, well, I don't have anybody, so I can't do this. For your power of attorney, healthcare proxy, look at the people in your life. And it doesn't always have to be a traditional family tree structure. It can be someone you have known, but who, as a family member, who's distant, but who still cares. Always better to have someone than no one. So think about that. There are professional organizations that offer those services, and many of them are really, really, they're competent and they're nice and they're useful. So take advantage of that too. But we're always here to help with that. Another question is, why does a trust cost more than a will? Well, as we talked about, trust, requires everything to be done ahead of time. So we're doing all the prep work, we're filling everything out, expanding everything early while you're feeling good, while you're alive. A will is all a will is a set of very simple instructions. Even if it's a 30-page will, it's still a set of instructions that only goes into effect after death. And then someone has to pay a lawyer and do the probate. So, of course, it's cheaper now, but you pay way more later. A trust, you're doing everything, you're front loading everything so that the next stages can be less expensive and less stressful. My will has a trust option in the event of both of our deaths for my son who has autism. Is this the same as the trust you mentioned? Yeah, so this it's a little different, but yeah. So basically, what you have is called a testamentary supplemental needs trust. So in wills, just again, planning goes in every direction. When you have a will, and if it's done properly by a professional, you may have a minor provision. You may also have a supplemental needs trust. So if you have a child with autism, you have a child that has either a cognitive issue or some other problem, then money will be set aside in that supplemental needs trust. So the way it would work mechanically is you pass away, you have assets in your name alone, with no beneficiary, no joint account holder. That asset would then flow through probate. It'd be a probate asset, and then your executor would make sure that a trust is set up with the named trustee in your will to set up that supplemental needs trust for your son, and then the money would then filter into that trust, be managed by that trustee under your will, which is called the testamentary trust or S&T, and then it would be used for their lifetime, and it'd be set up in a bank or financial institution, pay all the bills that's not covered by entitlements. And that's exactly what it is. Well, I've kept everybody almost till 2 o'clock, and what we can do is, again, if there are any additional questions, you can certainly reach out to our main number, 621-8640, area code 845, and then we can really dig into depth, and we can talk and see how we can help you. But I really appreciate all of you that joined today, and again, it's a pleasure, and I hope this in the month of independence also leads you in a good independent frame of mind. My name is Alan Feller, speaking for the Feller Group PC, and enjoy the rest of your July.